Supreme Court dismissed the criminal appeals by HIRALAL BABULAL SONI seeking return of gold bars and allowed appeals by Nandkumar Babulal Soni and set aside his conviction and sentences under Section 120B and 411 of IPC. The court also said that since the seized gold bars were recovered from the Nandkumar Babulal Soni is entitled to the possession thereof. The offence in this case pertains to the commission of fraud by remittance through fake telegraphic transfers and subsequent withdrawals to the tune of rupees 6 crore 70 lakh at Vijaya Bank, Nasik, Maharashtra. On 30 January 1997, one person disclosing as a representative of MS Globe International Proprietary Concern approached bank for opening account which was not immediately accepted by the accused branch manager as he wanted to verify the documents as there were difference in signatures. However, since one Surendra Bhandari, Assistant General Manager Vijay Bank, confirmed the letter of introduction issued by him, the personal presence of the proposed account holder was dispensed with and the account was opened. It is the case of the prosecution that the documents submitted at the time of account opening were forged and the person representing the firm, namely Surendra Jain or the firm Globe International, were fictitious. At the relevant time, Vijay Bank offered a service facility to all its customers whereby money could be remitted through the means of telegraphic transfer. If a customer desired to remit funds urgently from one place to another, he could deposit cash and request the remitting branch to set the amount to the credit of a particular account. Upon receipt of money, remitted branch would generate a code which was then sent via telegram to concerned branch in which account of the beneficiary was operational. Upon decoding, the receiving branch would then credit the amount to account of the beneficiary and send bank adjustment requisition form to the remitting branch, which upon receiving BARF would send a credit advance to receiving bank. The accused became suspicious of the transactions taking place in account of MS Globe International. On 12th 8 to 1997, he informed Vijaya Bank about the fraud and resultant payment against 19 demand drafts amounting to 1 crore 61 lakh 44,000 was stopped. On this date, there was a balance of 1 crore 53 lakh 27,178 in account of MS Globe International as against total credit through TTs amounting to rupees 6 crore 70 lakh. The bank initiated departmental proceedings against the accused. However, subsequently, both of them were exonerated of the charges. The 205 gold bars mentioned in the communication dated 30 May were later on seized by CBI. 110 TT bars of ARI make 30 of Harmony and 57 of Johnson Matthew, 6 of Credit Suisse, 2 of Pam Suisse Mark. The evidence of the aforementioned witnesses on charge of conspiracy revolves around Mukesh Shah at the rate Mayur Desai, who is absconding, who purchased the gold bars along with the appellant. Trial court concluded the following: conversion of money into gold bars itself brings accused near to offense. If conversion would have led into land or saving certificate, then that would have been a remote circumstance. Accused 3 is a jeweler and his family is in the same profession. In the evidence of prosecution witness 21 Bhavarlal Javartaj and prosecution witness 26 Prakash Jain, they have stated that Mukesh Shah was a new party, hence there is a reasonable ground to believe the dealings of gold bars through Nandlal Soni was easily accessible and workable. For providing the charge under Section 411 IPC against appellant, the prosecution relied on Section 106 of Evidence Act to say that if the appellant, having been found in the possession of 205 gold bars, it was for him to explain the source of acquisition. Prosecution ought to have been produced evidence to show that there was stock of the same brands with Chenaji Narsingji, and out of that stock, some gold bars with marking of Harmony Swiss Jensen Matthew Arya were sold to Globe International. In the absence of this evidence, and especially due to delay of 4 years in the recovery of the property, the base of its identification is found weak and degree of proof required is higher. The possibility of mistaken identification cannot be ruled out. Supreme Court observed that trial court proceeded to hold in para 120 that the property article 2 before the court is not proved as the same property, that is the seized gold bars which was sold by MSCN to Globe International. However, surprisingly, the trial court concluded that the fact that the gold was sold through fraudulent demand drafts from MSCN to MS Globe International, it can be held that appellant has received stolen property with knowledge. It was held that gold bars found with him may be a stolen property or he might have handed over to the absconding accused Mukesh Shah or any other accused. It was also held that after receiving stolen property, it may change the hand, so accused may not have entertained the property, but the fact that he has received the property is proved beyond reasonable doubt. Therefore, the evidence brought forward by prosecution is sufficient to hold that the accused is guilty under section 120B and 411 of IPC. The High Court found that while addressing the change of commission of fraud, the High Court observed that circumstantial evidence does not establish the guilt of the accused 1 and 2 in committing fabrication of the documents, and therefore the conclusions drawn by the trial court of this aspect are erroneous. In respect of charge against appellant, in his statement recorded under section 313 of CRPC 1973, particularly his answer to question number 133 regarding seizure of 205 gold bars from him, that these were legally acquired by him, the High Court proceeded to examine as to whether he has proved lawful acquisition of the gold bars, and eventually concluded that the appellant had failed to prove his case about the acquisition of seized gold. It seems that High Court was impressed with the fact that at the time of the search, the appellant resisted the Central Bureau of Investigation by wrongfully confining its officers. Basing this, High Court observed that the act of resisting the police from taking search is not consistent with the innocence of the appellant, and that if he substantiated his case on of lawful acquisition of gold, failure of the witness connected with MSCN to identify the seized gold would have become relevant, as there is no description of gold except for quantity and weight in the bills under which the gold was allegedly sold to MS Globe International. The High Court proceeds to conclude that basing above evidence and finding notwithstanding the delay in seizure, the clause A of section 114 of Evidence Act will have to be invoked. While dismissing HIRALAL's appeal for return of seized gold bars to him, basing an ex parte decree in his favor, the High Court reasoned that in the ex parte decree the state was not a party and there is no proof that HIRALAL has acquired the seized gold bars. The circumstances considered by the courts below to sustain the appellant's conviction under section 411 and 120B of IPC can be summarized as follows. CBI officials were resisted at the time of search and seizure in appellant's jewelry shop. Letter issued by MS Chenaji Narsingji to CBI containing an endorsement in favor of the appellant. Gold purchased by utilizing demand drafts drawn on the account of MS Globe International was stolen property. The appellant have business relation with MS Chenaji Narsingji and VB Jewelers. The appellant failed to substantiate his defense set up in his accused statement while answering question number 133. The appellant having failed to substantiate his defense in clause A of section 114 of Evidence Act will have to be invoked. The evidence of handing the over of the demand drafts by the appellant to MS Chenaji Narsingji and MS VB Jewelers and taking delivery of gold bars finding by the trial court, Supreme Court held that it is settled law that however strong a suspicion may be, it cannot take place of proof beyond reasonable doubt. In case of Kamal versus State National Capital Territory of Delhi, it was observed that conclusion of guilt is to be drawn should be fully established. It has been held that the circumstances concerned must or should and not may be established. It has been held that there is not only a grammatical but a legal distinction between may be proved and must be or should be proved. It has been held that the facts to establish should be consistent only with the hypothesis of the guilt of the accused, that is to say, they should not explainable, or any other hypothesis of the guilt of accused, that is to say, they should not be explainable on any other hypothesis except that the accused is guilty. In the case at hand, the trial court has held in para 120 that whether the gold bars which were sold by MSCN to Mukesh Shah of MS Globe International are same or not has not been proved beyond reasonable doubt. It is held by trial court that the distance between may and must is very vast and prosecution has to cover that distance to reach the destination of must. However, prosecution in this case could not achieve that level of proof. With this finding in the trial court, it is surprising as to how the appellant can be convicted for committing offence under section 120B and 411 of IPC. Once the courts below have found that the seized gold bars, Article 2, are not the same gold bars, conviction under 120B and 411 of IPC cannot be sustained. Similarly, the High Court impliedly held that witnesses connected with MSCN have failed to identify the seized gold. However, in opinion of the High Court, the same is not relevant because the appellant has failed to prove lawful acquisition of gold. The court said that we fail to understand when the prosecution has failed to prove the identity of seized gold as being the same gold as were sold to MSCN to MS Globe International, how the appellant is liable to prove lawful acquisition of gold vis-a-vis the stolen gold. In order to bring home the charge under section 411 of IPC, it is the duty of the prosecution to prove that the stolen property was in the possession of the accused, that some persons other than the accused had possession of the property before the accused got possession of it, and that the accused had knowledge that the property was stolen property. In Mohanlal versus State of Maharashtra, the court held that the prosecution has to prove that the accused was in the possession of property which he had reason to believe that it was a stolen property. When the prerequisite evidence to bring home the charge under section 411 of IPC is considered in present case, even if it is proved that the appellant was handed over the demand drafts by Mr. Mukesh Shah and gold bars were purchased by the appellant from MSCN and MSBB Jewelers, still it was necessary for the prosecutors to prove that the appellant either had knowledge or reason to believe that the demand drafts had been obtained through fraudulent process to make gold bars as stolen property in hands of the appellant, or the appellant was part of the conspiracy. Moreover, the appellant had not been charged or tried for the first part of offence relating to criminal conspiracy vis-a-vis the fraudulent TTs. The trial court has held that in para 115 that the prosecution ought to have produced evidence to show that there was a stock of the same brand with MSCN, and out of that stock some gold bars with markings of Harmonisius, Johnson Matthew, Arya were sold to MS Globe International. In absence of this evidence, and especially due to delay of 4 years in the recovery of the property, the very basis of identification is found shattered and the possibility of mistaken identification cannot be ruled out. With this finding of the trial court, invocation of section 114 of Evidence Act is not at all permissible, since the prosecution has failed to discharge its initial burden. The prosecution has to prove its case beyond all reasonable doubts by positively completing the chain of circumstances against the appellant, which the prosecution has utterly failed in the present case.